Hello everybody and welcome to this Trademarks introductory talk. My name is Edward Carstairs and I'm a partner at Gill Jennings Every, which is a specialist IP law firm based in London and Munich. I'm a qualified UK and European trademark attorney, so I primarily help our clients protecting their brands. I work with businesses across a variety of different sectors, including food and drink, fashion, sportswear, consumer electronics, media and entertainment, and financial services. I also work with businesses at various stages, from startups all the way through to large multinationals. We also have specialist patent attorneys in our chemical and life sciences and IT and engineering teams, providing both patent and design advice. This is part one of our talk today, where we'll be looking at the various issues connected with protecting trademarks. In this first section, we will be looking at the overview of what makes up a trademark, as well as what a trademark is and how you can protect it. Throughout the talk and the three parts, we'll be looking at what is a trademark, we'll be looking at how you select a trademark, we'll be looking at freedom to use, ownership and control of your IP, how you file and register your IP, and your trademarks. We'll look at enforcement, and we'll finish off by looking at some common misconceptions. So, dealing with our first question, what is a trademark? There are a couple of answers to this question. The first is the legal definition. So, a trademark can be made up of words, including personal names, designs, letters, numerals, colours, sounds, or shapes. So, as long as the trademark can distinguish the goods and services of one undertaking from those of another, it can be registered as a trademark. And we've got a few examples here, being the Starbucks logo and the Audi logo. We've got McDonald's "I'm loving it" slogan. We've even got the shape of the Coca-Cola bottle. Usually the trademark is the name of a product or service, compared with, say, the content of a training course, which might be protected via copyright. It's also important not to overlook the commercial situation when you're thinking about what is a trademark. A trademark is more than something that just sits on the register, so every business will have at least one brand. Usually, that will be the name of that business. Think about when a business is sold. What is it that is actually being purchased? There is always at least a brand name involved, and when you think about many businesses today, the brand name has significant value attached, whether it's something like Facebook, Nike, or Apple. The consumer loyalty that brand attracts is of significant value. So as such, a trademark is a business asset that can be bought, sold, licensed, or mortgaged. The value of that business asset is in part dictated by the technical legal strength that right provides to allow the owner to stop a third party using or registering something that's similar. When you have a registered trademark in place, it's easier to enforce compared with unregistered rights, which is a heavily evidence-based exercise. And indeed, many countries give little or no recognition at all to unregistered rights. Do note that any trademark is, of course, territorial, so protection in one country doesn't mean that you have the right to prevent a third party from doing something similar in another territory. So, when selecting a trademark, and you also need to think about making sure that you have freedom to use that brand, you need to pick the right brand. You need to pick something that's distinctive and that's not descriptive, and that doesn't clash with a third party. You need to be creative when you select your brand, when you select your trademark that you might register. So something like Amazon for books or Apple for computers and phones is going to be much easier to register, protect, and enforce than a name that simply describes the product or might be considered a promotional message like "simply the best." You need to conduct clearance searches to check that you're free to use and register that mark. So in other words, you're not going to get sued by someone else. Clearly, that's going to be a very expensive exercise and at the very least be very bad publicity for you and your business. Remember that simply owning a registered trademark doesn't mean that you're free to use that trademark. It could simply be the case that a third party with a conflicting earlier right simply didn't spot your application when it was filed, and then they come out of the woodwork a few years later down the line to both cancel the trademark that you registered and also to take action against your infringing use. So this is why before filing or commencing use in a new country, it's always advisable to conduct searches to determine whether there are any earlier rights that your use might infringe, and that could be a strong basis to oppose an application. So both identical and similar earlier marks for identical and similar products will be relevant. If an earlier trademark is located, then it means you avoid the potential problems of a trademark infringement action being brought against you, as well as saving the cost of filing what would ultimately have been a failed application. You need to consider your business plan when you're selecting a trademark. You need to plan ahead. You need to think about your key markets. Is the US going to be critical to your success? If it is, then make sure you've run freedom to operate searches there. Is it going to be important to trade under the same name across all territories? Split branding can work, but for most situations, it's not going to be the ideal scenario. It's going to be more costly for packaging and advertising, and it can cause confusion amongst your own consumers. It's also going to be a big red flag to any potential investor or purchaser of your business if you can't say that you're free to use your brand name in your core market. It's going to lead to an instant reduction in value. This is an important issue to consider early on, and we'll return to this before the end of the talks. You need to think about what your short and long-term goals are for your business. For example, is there going to be some kind of product expansion later down the line? You don't want to limit yourself at the outset. So bear in mind that when you're preparing your specification of goods and services that you cover with your trademark, make sure that you future-proof those potential interests later down the line. If any products are of interest and missed at filing, then you'll need to file another top-up application at a later stage. And that, of course, will attract further costs and your own time in dealing with it. Fundamentally, when you're selecting a new trademark and running freedom to operate searches, it's a risk analysis exercise. You need to seek professional advice as to the level of risk posed and what actions you can take to mitigate those risks. Now, we can go through some examples here, some real-world examples to illustrate the kind of issues that do come up. Little Mix were originally known as Rhythmix, but once they appeared on TV, they received objections from a Brighton-based charity that was trading under the same name. So either they didn't run any searches before adopting the Rhythmix name, or they did, and they located the charity and decided that this wasn't going to be a technical legal risk. Well, either way, the issue arose, and there was a natural commercial problem with potential bad publicity associated with coming up against a charity. So they changed their name to Little Mix and managed to avoid any ill effects. The Monzo Bank was originally known as Mondo, but they received objections from an unknown third party. They managed to turn it into a rather clever PR stunt by asking for submissions for alternative names, and Banking at Bankface was obviously a suggestion. Now, this campaign raised awareness of the change and also got consumers on board, so it averted any kind of disaster and was actually a rather positive exercise in the end. The Olay cosmetic brand was originally known as Oil of Ulay, but that entity needed to take into consideration the different meanings of Ulay, U-L-A-Y, in different countries around the world. So in the Philippines, Ulay means tapeworm. Now, there are clearly negative connotations attached there. So as the product expanded into these other territories, the business made the decision to standardize their branding across the world rather than have multiple different names in different countries. So Oil of Yulan, Oil of Olaz. Fundamentally, this speaks to the importance of planning ahead and considering your potential international expansion. We have a few more examples here of other brands that have rebranded over the years. So Weight Watchers are now the WW logo, which is in line with their shift in focus away from simply being a weight loss product to overall health. Now, of course, this change in branding means that more searching and filing is needed. And of course, it's difficult to predict those kind of changes in consumer attitudes to dieting and lifestyle. But having adopted less technically legally distinctive trademark in the first place, it makes the process of change a little more difficult. One, from a legal point of view, because they now need to search, clear and register the new brand. And two, they need to educate their consumers about this change of branding. In the case of Diamond Sif, they are examples of branding that was changed to ensure that all the countries were in line across Europe with the same brands. to make sure that there's consistency in the marketplace. So naturally for these businesses, those changes will have been expensive in the short term with more searching needed and filing new trademarks, but longer term, it can lead to better cost saving options available, given that there'll be consistent packaging and marketing and so forth across all of the regions relevant to that business. So that brings us to the end of part one of this introduction to trademarks. If you would like any more information, then you can find it at our website, www.gge.com. Or if you have any questions about what we've gone through in this first part, you can email me at edward.carstairs@gje.com. You can also connect with me on LinkedIn, and you can find this video and other videos at our YouTube page at the link below. So stay tuned for part two.